Hello, everyone, and welcome to another live edition of Employment and Disability Law Q&A. Welcome to all. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We specialize in and are national and Canada leaders in employment law and disability insurance law. This is, as I mentioned, a live Q&A. We are here to answer your questions, help people resolve their workplace problems, whether they're dealing with an issue with their boss or with their employer. Maybe they've been terminated from their employment. Maybe they are in a disagreement with their employer about the terms of their employment, or whether you as an employee are on a medical leave of absence. Maybe you're dealing with an insurance company and disability insurance. Maybe your employer is giving you a hard time about your medical issues, either accommodations in the workplace or your leaves of absence. Really, when it comes to any issues related to your employment, we are here to help. We are here to answer any and all questions when it comes to your employment. We, as our longtime viewers and listeners will know, we do these Q&As throughout the week. It's an opportunity to, again, help people resolve their workplace situation. So again, welcome all. For those of you that are just tuning in, again, this is a live Q&A. And so go ahead and post your questions online. They could be completely anonymous. Do not mention your employer's name. You don't have to provide any specific details. Ask your question in a general format, and I promise over the next half an hour, we will get to it, and I will help you on your way to resolving whatever issue you may be having. As is usual, at the top of the show, we always like to provide our contact information. If you're looking to get a hold of us, perhaps off a live stream or off live air, give us a call at the office. We have an entire intake team standing by to field questions, set up calls with our lawyers. The first place you should visit is certainly our website, employmentlawyer.ca. You see it on the screen right now. Go ahead and visit us at that website for a number of different reasons. Number one, we have all of our contact information on the website. You can give us a call at the office, toll free completely. Secondly, we have a ton of resources on our website. We have articles about basic employment law issues. If you want to get a good sense of your situation and just a kind of a preliminary sense of what you might be dealing with, go ahead and find a couple of articles on our website. They will be very useful. We also have a ton of video clips from our shows that we do, from our radio shows that we do. And again, you can just find a ton of resources on the website. You can also, of course, give us a call. Give us a call at 1-855-821-5900. You can reach us at that number. Again, we have an entire team of well-trained, capable intake staff that are standing by, happy to field questions when it comes to your employment situation. Another option that you have, as you could tell, there are multiple options here. There's no difficult way to get a hold of us. Email us. help@employmentlawyer.ca is the email address. You see it on your screen right now, help@employmentlawyer.ca. Go ahead and send us a brief email. Describe the situation that you're dealing with. Do not send us 12 attachments and a 10-page story of your entire work history. Give us a brief synopsis, a brief introduction of the situation that you're dealing with, and I promise someone will get back to you at that email address. Those are the ways to contact us, guys. Again, telephone number, email address. Otherwise, go visit our website. Of course, all of the individual lawyers that we have, and we have lawyers across the country of Canada, specifically in British Columbia, Alberta, and Ontario. You can find all of our lawyers' contact information there as well. And that's our contact information. Once again, for those of you just tuning in, this is an employment and disability law Q&A. My name is Alex Lucifero. I'm an employment lawyer, a disability insurance lawyer, partner with the firm Samfiru Tumarkin, LLP. Again, this is a live Q&A. We're here to answer questions for those of you tuning in and dealing with a situation at work, whatever that situation may be. Maybe you have an issue with your pension contributions. Maybe your employer is trying to change the terms of your employment, change your schedule, or return you to work after working from home for a period of time. Maybe you've been let go from your job, unfortunately, and you've been offered some sort of severance package, and you're not sure whether it's reasonable or not. You might have a sense of whether it might be, but you want to do your due diligence. Please go ahead and give us a call, contact us, or even better, if you're tuning in right now, go ahead and post your question on whatever platform that you're watching us on. Again, it can be completely anonymous. Don't give us any specific details. Ask the question in a general format. I promise I will get back to you and answer your question over the next 25 minutes or so. To get us warmed up for this Q&A and get you thinking about employment law and the various issues that can arise when it comes to an employment law situation, I wanted to talk to you about a matter that just came across my desk actually this morning. So this is hot off the press, as they say. Situation, I spoke to a very nice gentleman, older gentleman, this morning. He had only been with his employer for about a year and a month or so. So relatively new employee still to the company. He was in a kind of technical role, so he had a kind of computer engineering background, and it wasn't a managerial position by any stretch of the of the situation, but he was in a very specialized kind of skilled position. And this gentleman, he's in his late 50s, was dealing with an issue just prior to his termination. He had actually reached out to his employer, to his direct manager, and he had raised concerns about the fact that he wasn't feeling well. He had gone to see his doctor. He was feeling extremely fatigued. He wasn't sure why, and he just wasn't feeling physically well. He hadn't taken any medical leave, so he didn't take any time off. He was still doing his job, and he had made an appointment with his family doctor to discuss these issues, maybe do some testing, kind of try and figure out why he was feeling this way. But he mentioned this issue to his manager as kind of a heads up to say, this is what I'm feeling right now. Kind of bear with me. I'm trying to figure this out and work through. Again, he was dealing with extreme fatigue. Lo and behold, some 2 weeks later, and that was the end of the conversation. The issue wasn't brought up any further. Again, this gentleman was doing his job to the best of his ability, and my understanding was he was doing an absolutely fine and good job, but he was having some medical issues personally. Lo and behold, after he mentioned this to his manager, some 2 weeks later, he was let go from his job. He was sat down in a meeting and effectively told, we're making a change to the department. Unfortunately, your position is being eliminated. We're letting you go. And they offered him as a 1-year employee. Again, this is a gentleman in his late 50s, 1 year with the company in a kind of specialized technical computer-related role. He was offered 5 weeks of severance, 5 weeks of what they call termination pay. And so this gentleman reached out to us, sent me his documents. We had a chat over the phone. And what I told him was, these circumstances are quite suspicious. It is quite suspicious that you mentioned to your manager that you were dealing some health issues. There were, otherwise no performance concerns. Things were going well with the company. And lo and behold, 2 weeks after he says that to his manager, he's let go. Now, his termination letter did mention that his position was being eliminated, right? And if that is in fact true, if that is the reason why this individual was let go from his job, his position no longer exists. They've restructured his department, right? And that position is not going to be existing with the company anymore. If that is true, then the termination is legal. There's nothing that could be done about the reason for letting him go. And this is actually an important point for everyone. Lots of employees will get caught up in the reason for termination and the circumstances of the termination. And I would say a good 90 to 95% of the time, the actual reason for termination when it comes to letting an employee go is irrelevant. And the reason why is that an employer is well within its rights actually to let an employee go. There's nothing stopping an employer from letting an employee go in the non-unionized, in the private work sector, as long as the correct amount of severance is paid. And so it is severance that is ultimately the legally actionable issue when it comes to a termination of employment. The reason for termination in most cases, the majority of cases, I would say, doesn't matter. Where it does matter is if the reason for termination was potentially discriminatory. And that's what we might be dealing with here, because this gentleman had mentioned struggling with his health a couple of weeks prior, right? If any part of the reason for letting this employee go was related to that conversation and related to the employer's concerns that this employee might go on a medical leave or might have medical issues that need accommodation. If any part of the company's decision-making process was related to that particular issue, that is discrimination under the Human Rights Code in Ontario. That is illegal. You cannot let an employee go because they're dealing with medical issues or because they might take a medical leave or might need accommodation in the workplace as a result of their health issues. So this is now going to be our job as point number one. We need to figure out whether his position was in fact really eliminated, right? Or alternatively, if the position wasn't eliminated, and let's say, for example, this guy is just replaced in his position by another employee, that's going to be a big problem. If the position isn't actually eliminated, then that points to the reason for termination being his having raised those health issues that we're dealing with. So that is step number one. Step number two is the severance offer itself. And this might be shocking actually for some to hear, but the reality is that 5 weeks of termination pay or 5 weeks of severance for an employee in their late 50s with 1 year of service in a specialized technical role is not enough severance. Right? An employee, even of just 1 year of service, is likely looking at a severance package, I would say, in the range of very easily and kind of generally something like 3 or 4 months. It may even be more than that potentially. And so even short-term employees such as this gentleman, and again, regardless for the reason of his termination, even short-term employees such as himself are going to be owed significant severance package, not just a couple of weeks pay. They're going to be looking at months as a severance package. And again, this gentleman is likely going to be looking at something in the range of, I would say, 4 months. So a good lesson, and the reason why I wanted to bring this issue up, a good lesson for our listeners and viewers here, when you're dealing with the termination of employment, it's important to assess the severance that you've been offered. 90% of the time, a severance offer by an employer will not be adequate. It will be insufficient, and employee severance entitlements are actually much more than what employers will typically offer. Secondly, it is important to examine the reason for termination, especially when we're dealing with human rights issues, whether that's on accommodation or some sort of discrimination on the basis of either disability, gender, or race, etc. And so there are always a couple of issues to bring up when we're dealing with the termination of employment. Hopefully, that lesson is something that you can take something away from. Hopefully, you're never dealing with a termination in those circumstances. But if you or a family member or a friend or a colleague ever find themselves let go from their job, the advice would be do not just sign off on the dotted line if your employer is asking you. Make sure that you speak with an employment lawyer first before you accept any kind of severance offer from the company, and make sure that you discuss the reasons for the termination as well. All right, and with that out of the way, we'll get to the questions. Again, for those of you just tuning in midway through the segment, once again, and you saw on the screen a couple of moments ago, my name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. This is a live Q&A regarding employment law and disability insurance law. If you have questions about your employment and you are in Canada, and specifically in British Columbia, Alberta, or Ontario, go ahead and post your question right now. We've got about 15 minutes left on the segment to get to those questions, and that's what we're going to do right now. So here comes the fun part for me. It's always a pleasure to answer questions here, guys. Please do not be bashful. Do not be shy. This is the most interesting part of these segments. Thanks to you posting your questions. So again, go ahead. Don't be shy. Go ahead and post your question right now. First question of the day, first in line from YouTube, is Serena. Serena asks, how long do you have to be off from work before you can claim LTD? LTD being long-term disability. Good question, Serena. There is a specific period of time. The way it usually works is you go off on a medical leave of absence. Of course, in that situation, you need to provide your employer with a doctor's note. Your employer doesn't have the obligation to just take your word for it, right? It's not like, calling in sick one day. If you're going to be off for an indefinite period of time, your doctor needs to provide a note. Your doctor, by the way, doesn't need to tell your employer what the diagnosis is. Your employer doesn't have the right to know the specific medical issue that you're dealing with. They do, however, have a right to know what the general prognosis might be, meaning how long might you be off for, if your doctor is able to assess. Typically, what we'll see, at least at the early stages, is a doctor will give an employee, for example, 1 month medical leave, and then you make another appointment with the patient 1 month from then. Perhaps you get a second note at that point if you're still not able to return back to work. And so it'll kind of work in 1 month increments. If you're dealing with a much more serious medical issue and you're receiving longer term treatment, well, perhaps that might be 3 months, perhaps even 6 months if it's very serious. But there should be some sort of note provided to your employer. The next step, and this is specifically, Serena, if you are in Ontario. I cannot necessarily speak to any of the other provinces in Canada. I also can't speak to anything in the States, for example, or in any other country for that matter. But in Ontario, your insurance policy will require you to apply for what's called employment insurance sickness benefits. So this is through effectively the government. It's actually the federal government, where you will receive basically EI, employment insurance, although it's specifically for people medically unable to work, for what's something like, I think, 15 weeks or approximately 14 or 15 weeks, something like that. You will then, Serena, be able to apply, if you have coverage, to short-term disability benefits. Short-term disability benefits typically last for a few months, something like perhaps 4 months or so. And at that point, Serena, you will then be able to apply for long-term disability benefits. Long-term disability benefits kick in after employment insurance and after short-term disability benefits. And so it's several months from the actual start from your medical leave of absence. That's when LTD, or long-term disability, kicks in. And that will last up until you are medically able to return back to work. Insurance companies, rather, and I hate to say this, I say this begrudgingly, insurance companies will give people a hard time when applying for LTD. You will have to provide a physician statement, of course, as part of your application. A lot of times, insurance companies will come back and ask for more information and ask for clarification. And even when they do something like that, they will deny an initial claim for disability insurance. It is commonplace. Commonplace. It happens more often than any one of us would think that insurance companies deny legitimate claims. If that happens to you, if you have applied for disability insurance and you've been rejected, despite the fact that your doctor is ordering you to remain off of work and remain on medical leave of absence, please give us a call right away. Don't try and fight with the insurance company yourself. Don't file an appeal either. Speak to a disability insurance lawyer as soon as possible if you've been denied. Odds are, if you have your doctor's support in taking a medical leave of absence, odds are the insurance company has made a mistake, and they need to be shown in no uncertain terms that they've made a mistake. And the only way, or the best way rather, that you can do that is by engaging with a disability insurance lawyer. Again, this is something that we've been doing for quite some time. We are specialists in, and so you want to make sure that you speak with one of our disability insurance lawyers if you've been denied LTD or even short-term disability benefits for that matter. Serena, thank you so much for the question. Christina is up next, again on YouTube. She asks, if you're in the process of applying for LTD and your employer says they are going to restructure and you may lose your job, are you still able to get coverage? Christina, another great question. Thank you so much, guys. The questions are at a very good level today. Christina, the short answer is yes. As long as you are still employed with the company, despite the fact that they may restructure your job and that you may be losing your job, you can still apply for LTD. I think what that means, Christina, is you should apply sooner rather than later. That said, Christina, depending on the length of your employment, depending on how long you've been with the same company, even if you are terminated, you would still have a certain amount of time post-termination to be able to still completely legitimately apply for LTD, although that period post-termination might depend on how long you've been employed for. So my advice, Christina, would be if you haven't lost your job just yet, but you fear you may lose it, go ahead and apply for disability insurance as soon as possible. Of course, you need your doctor's support in applying for LTD. Your doctor needs to be able to, very clearly and unequivocally confirm that you're completely unable to work, right? If you have your doctor's support, go ahead and apply right away. Don't wait. It's not worth it. It does become potentially more complicated if you've been let go, although it's not the end of the road per se. You'd still have a certain amount of time post-termination, depending on your length of employment. Any further questions, Christina? Any further clarifications? Don't be shy to give us a call at the office. Don't be shy to email us at help@employmentlawyer.ca, and we can take it from there. All right, the questions are flowing in, so I will speed it up a little, guys, if you don't mind. Again, if you're just tuning in, this is a live employment law and disability insurance law Q&A. My name is Alex Lucifero. I'm a partner with the firm. I've been practicing employment law and disability insurance law for quite some time now. So if you're looking for some guidance, if you're looking for some information, go ahead and post your question right now. We've got about 10 minutes left. Trust me, I will get you moving in the right direction when it comes to your concerns. Laura on Facebook asks, my husband's company was recently sold to a new owner. Always an interesting situation for an employee. He kept on, but the owner has created a hostile work environment. Does he have any options here? He doesn't want to quit as he'll forego his severance package. Laura, you're absolutely correct. It is always, let's say, the worst case scenario for an employee to be just quitting for nothing in response to a difficult, poisoned, or hostile work environment, or when you're dealing with workplace harassment. The question I would have, Laura, when you're describing a hostile work environment is, what are we really dealing with here? In terms of what is the actual day-to-day situation that your husband is dealing with? Is he being sworn at by his boss? Is he being picked on by other colleagues or other co-workers? How bad are the circumstances really? Because harassment in the workplace or a poisoned work environment, and these are kind of legal definitions, they have to meet a certain threshold. Your boss not saying good morning to you in the morning, or maybe being a little chippy or not particularly nice, that's not going to rise to the level of a poisoned work environment. But of course, serious bullying or harassment in the workplace is oftentimes quite obvious. In those situations, Laura, if your husband is dealing with a relatively obvious situation where it's kind of very clearly inappropriate conduct, he shouldn't be quitting for nothing. That might be what's called a constructive dismissal, meaning the employer might have created such a bad environment that your husband can actually consider his employment terminated. It's basically a breach of contract kind of situation where the employer's actions have breached the terms of employment, and that would allow your husband to claim severance while quitting effectively. Now, before your husband goes to the company and asks for severance, or decides to quit and ask for severance, don't do that. Don't do that, Alora. Tell your husband to give us a call at the office. Let's schedule a time to chat. Let's talk through the details of the kind of environment he's working in, and then we'll figure out his options moving forward. I can tell you we resolve these kinds of situations every single day. Oftentimes, not always, but oftentimes, an employer is willing to negotiate an exit package in these situations. It's not uncommon at all. So that might be an option that's on the table. Otherwise, maybe we can try and resolve the situation and have your husband keep his job. Maybe that's not a bad situation either. So give us a call at the office, Laura, and we could talk through the options and we could figure out what exactly your husband should be doing moving forward. Before he does anything himself, he needs advice from an employment lawyer, that's for sure. All right, MP asks, how important is it to go into the details of a termination without cause letter as to why an employee was terminated? Another excellent question, MP. I was actually speaking about this at the start of the show. In most cases, MP, the reason for termination will not matter. It really becomes only a question of how much severance is owed. The reason why that is because an employer doesn't really need a reason for letting an employee go. There's nothing wrong with an employer inherently letting an employee go. An employer is allowed to do that. They don't even need to give the employee a reason. It could be that it's not a good fit, right? It could be that they're maybe replacing that employee with an employee whom they could pay less. That's a legitimate reason as well. The only time it'll matter, MP, is if we're dealing with, again, a human rights issue. In other words, discrimination. If you feel like you might have been terminated without cause on the basis of either a disability or your gender or your race or your nationality or your ethnicity or your religion, those are potentially problematic situations where the reason for termination may very well be extremely relevant in addition to the severance analysis. All right, Nadine asks, if your manager delivers a PIP, PIP is a performance improvement plan. If your manager delivers a performance improvement plan based on behaviors and competencies after coming back from a sick leave and serves verbal warning for attendance, do you have to sign or can they reprimand you? Good question, Nadine. It depends what you're signing for. So if the signature is to simply acknowledge receipt of the performance improvement plan, I don't particularly have an issue with that. There's no question, obviously, that you've received it, right? However, if the signature line is acknowledging that you've read the performance improvement plan and you agree with it, and you don't agree with it, well, then that's obviously a problem. And in that case, I would very respectfully and very even politely, Nadine, say that you're not signing. What I will typically recommend when we're dealing with a performance improvement plan, and this is, of course, in situations where the employee doesn't agree with the performance improvement plan, it is that there's no value in getting tempers flared up. There's no value in this becoming antagonistic, right? You want to try and keep the temperature down. You want to communicate professionally, respectfully, amicably. I would send the employer back an email, send your manager back an email and say, thank you very much, I've had a chance to review the PIP. I do not agree with X, Y, and Z for the following reasons. And you explain why you don't agree with the performance improvement plan. You then say, for these reasons, I am not, I'm going to do the very best that I can in my job, right? And I'm committed to succeeding with the company. You want to show them you're still committed to your job, but I will not be signing the agreement. That, ladies and gentlemen, is how you respond to a performance improvement a plan word for word. If you don't agree with it, you remain respectful and professional. You clearly spell out why you don't agree with it, and as a result of that you're not signing it. I can tell you, Nadine, if your employer lets you go in response to that, it will not affect the severance analysis at all. Again, we can't really dispute the reason for termination. If they want to let you go, they can, right? Even if it's because of, for example, you not agreeing to that performance improvement plan, but your severance entitlements are not affected at all in that kind of situation. All right. Thank you all so much for the questions. We're going to start wrapping up now, but I think there are a couple more. Let's see here. Next in line is Diane. Diane on Facebook asks, if I go through human rights, can I revert to using a lawyer? I have asserted my rights and I am at the stage of filing an application, terminated without cause, stating restructuring with 3 weeks severance and 2 weeks if I sign a full release. I'm 58, held 2 positions with a small company. Diane, first things first, you can absolutely use a lawyer as part of a human rights claim. This is assuming, however, that you are in a non-unionized position and that you're not employed by, for example, the Federal Public Service. For government employees, even potentially if you're non-unionized, there are certain protocols and procedures and effectively kind of grievance processes that have to be followed that might make using a lawyer a little more difficult, if not impossible. If you're not a government employee and you're not a unionized employee, you can absolutely hire an employment lawyer, even when dealing with a human rights issue. You don't have to, it's not obligatory, but you certainly can use an employment lawyer as part of a human rights claim. I can tell you, in addition to any human rights issues that you've had, Diane, if you've only been offered about 5 weeks of severance and you're 58 and you had a pretty important position with the company, if you're covering 2 roles, I obviously don't know how long you've been with the company, but I can tell you that's likely an inadequate severance amount. And so right then and there may be a severance issue. Sounds like there may be a human rights component to the claim as well. Again, if you haven't spoken with a lawyer yet, go ahead and give us a call at the office, send us an email, visit the website, get in touch with our intake team. They'll put you in touch with one of our lawyers, and we can lay out the options that you have, give you advice on what your best option is moving forward. Sometimes, Diane, for example, a civil claim, effectively litigation or a court claim, is a heavier tool, so to speak, as compared to a human rights claim. So we may even recommend a civil claim against your employer for both severance and the human rights issues. I say that as an example. We need to go into the details of your situation, but give us a call. I think you'll be happy with the advice that you get, regardless of ultimately what you decide moving forward. All right, last 2 questions, rapid fire, if I may. Tim asks, I was recently let go, but I'm a bit confused by it. The letter says my date of termination was the same day I received it, but then outlines 3 additional weeks of work. Is that a notice period? Well, Tim, if they're still requiring you to work for 3 weeks, but you've been formally terminated, I guess that is a working notice period. Listen, if there's any uncertainty as to whether you should be working or not, right? Or what counts as severances doesn't. Ask your employer. There's nothing wrong with asking, what's the situation here, guys? Are you expecting me to work for the next 3 weeks or not? And if they tell you they're not expecting you to work, but they're going to pay you for 3 weeks, well, then that's fine. That counts as severance. The working notice, Tim, for what it's worth, unfortunately, if you have to work those 3 weeks, it also counts towards your severance entitlements. And so, listen, either way, 3 weeks is unlikely to be a reasonable severance period. Obviously, don't know your age, position, or years of service, but 3 weeks is, sounds pretty low. Visit pocketemploymentlawyer.ca, by the way, is a great tool that anyone can use to calculate what their severance entitlements are. You see it on the screen right now, pocketemploymentlawyer.ca, all one word. There's actually a severance pay calculator there. You can get a good assessment of what your severance entitlements are, as well as some other employment issues that are common. Rudy is last, right under the wire. Rudy asked, I got an email with a pay raise amount. 6 weeks later, I got another email saying I'm getting a lesser amount. Do I have any recourse? Rudy, great question. It depends whether you're unionized or not. If you're unionized, speak to your union about it. I imagine there might be an issue there. If you're non-unionized, Rudy, that becomes much more difficult because it depends on how much less we're talking about here. And actually, it actually makes it's a really relevant point. If your employer reduces your pay by a significant amount, and significant is not specifically defined, so it typically has to be something like close to 10% or more of, let's say, in this case, Rudy, a pay decrease, right? If that's what's happened here, that might be a constructive dismissal. It might allow you to seek severance here. If it's not, if it's a 1% difference in your pay, that's a tough situation, Rudy. There might not be a huge amount of recourse that an employee has, again, a non-unionized employee has in those circumstances. So the devil's in the details. Depends how much they've reduced your pay by most recently. Again, to get into specifics, give us a call, send us an email, describe your situation. Happy to help out in any way we can. We will leave it there, folks. This has been an excellent live employment law and disability insurance law Q&A. Answered a ton of great questions here. Thank you all for tuning in. Thank you, all of you who've asked questions. Not only have you helped yourself, you've also helped probably hundreds of other people watching who had similar questions, similar situations. And so thanks again. Have a great rest of the week, everyone. We will catch you here next time. Tune in for the next edition of Employment Law Q&A. I'm sure there is one coming up soon enough. Until then, have a great rest of the day, everyone. Take care.